falling out with my business partner. Can the company lawyer negotiate on my behalf to get rid of the other guy? So first, let me be clear that this video is directed specifically towards small and mid-sized private companies with a very small number of owners. The use of the phrase falling out suggests that under these circumstances and with this type of corporate structure, there's a good chance that both parties will need independent counsel. This is especially true in the very common setup of a two-owner company with a 50-50 split, although even then, maybe not. Since this question is phrased a bit broadly and ambiguously, let's assume that there's no operating agreement, buy-sell agreement, or shareholders agreement in place, or that the one that exists fails to give the parties a definitive path towards severing their relationship. Not to digress, but this is exactly why a little upfront investment to have a business lawyer draft these documents at the beginning can save you exponentially down the road. Anyway, under the applicable rules of professional conduct for essentially every state bar association, the company's lawyer is going to be ethically prohibited from advising you, the remaining partner, contrary to the departing partner's interests, unless the departing partner signs a conflict waiver. Of course, the reverse is true as well. The attorney cannot advocate on behalf of the departing partner against the remaining partners in their respective individual capacities without everyone involved agreeing to what would be a truly bizarre and convoluted situation in writing. With that said, it clearly would be in the company's best interest that this matter be resolved as swiftly and amicably as possible, and that the company itself be left in the strongest possible legal and financial position when all is said and done. So the company's lawyer can continue to act in that capacity. When the situation isn't acrimonious, but for whatever reason the partners are no longer willing to work together, I've successfully helped both sides to jointly develop a resolution for one partner's timely and amicable departure in a manner that makes the company whole. In this situation, it is imperative that both sides understand in advance that I cannot negotiate on either party's behalf or keep secrets or give favorable treatment to one at the expense of the other. From a practical perspective, as long as both parties are cooperating toward a resolution and are in agreement that the partnership needs to end and are essentially in agreement to the general terms upon which that should happen, this arrangement has worked quite well, and it saves both sides a huge amount on legal fees. But if at some point the dealings were to become irrevocably adversarial between the parties, I'd be conflicted out, and they would each need to retain their own 100% independent lawyer, probably a litigator, to resolve the matter on their behalf. That's a lot of wasted time and expense, so having company counsel act in this capacity is really only a viable option when, one, the parties just basically need someone to memorialize their mutual agreements and smooth out some minor deal points of the exit, and two, when their desired approach is clearly in the best interest of the company. If either of those conditions are not true, I take a big step back, and I'll likely only perform a review of the near final documents to ensure that the interests of the company remain protected. A situation involving multiple owners and varying ownership percentages can alter this calculus in a variety of ways as well. Some company attorneys won't think twice about negotiating on behalf of the remaining partner, even if it was a 50-50 split and the partner being kicked out arguably has just as valid a claim to ownership of the company as the other guy. And some company attorneys are so risk averse that they wouldn't touch this situation, even if the remaining partner or partners hold a supermajority of interests and there are reasonable grounds for removing the other guy for cause. So just because your lawyer approaches this situation differently doesn't mean that he or she is wrong, or that I am. Like a lot of things I talk about, there's a lot of gray area and room for discretion and professional judgment. Business owners, would you ever be comfortable with joint representation in these circumstances? Or would you always seek independent counsel no matter how amicable the separation?